The Supreme Court of the United States just handed down a ruling that could change the way every American election gets fought, not just in courtrooms, but at the ballot box, in state legislatures, and in the halls of Congress. And if you haven't heard about it, that's not an accident. This is the kind of decision that gets buried under celebrity noise and partisan shouting matches because it's inconvenient, too many powerful people at once. But it matters. It matters enormously. The case centers on Illinois, on mail-in ballots, on a congressman who had the nerve to say the process was broken, and on a Supreme Court that just said, in a 7-2 vote, that he had every right to stand in court and say so. This isn't just a legal footnote. This is a constitutional earthquake. And if you care about the integrity of the American democratic process, regardless of which party you vote for, and you need to understand exactly what just happened and exactly what it means for every election coming down the pipeline. If this kind of journalism matters to you, the kind that doesn't ask permission and doesn't pick a team, hit subscribe right now and turn on notifications, because this story is only getting bigger, and you deserve to hear it straight. Let's start with what actually happened in Illinois, because the origin story here matters. Illinois has a practice, and it's not unique to Illinois. That's important to understand. Where mail-in ballots received after Election Day can still be counted. In Illinois, under current rules, ballots can be received and counted up to 14 days after Election Day, provided they are postmarked by Election Day itself. To many people, that sounds reasonable. To others, it sounds like an invitation for chaos, for manipulation, for a process that never truly ends on the night it's supposed to end. And Congressman Mike Bost, a Republican representing Illinois' 12th congressional district, decided he wasn't going to just accept it. Bost filed a federal lawsuit challenging this practice, arguing that it violated federal law, specifically the federal statute establishing a uniform national election day. His argument was straightforward on its face. Congress set a singular election day, a single day when the American people cast their votes and have those votes counted. When states extend ballot receipt deadlines beyond that day, Bost argued they are in direct conflict with that federal standard. It's not a frivolous argument. Legal scholars across the ideological spectrum have debated this exact question for years. But what happened next tells you everything you need to know about how courts have traditionally handled election challenges. The lower courts didn't weigh in on whether Illinois' rule was constitutional or not. They didn't get to the merits of the case at all. They threw it out on standing, the legal doctrine that requires a plaintiff to show a direct, concrete, personal injury before a court will even hear the substance of their complaint. The lower courts reasoned that the disputed mail-in ballots, the ones counted after Election Day in Bost's own race, were unlikely to have changed the outcome of his election. He won his race. So what's the injury? That was the logic. And on the surface, you might understand that reasoning. But here's where it breaks down completely. Telling an elected official, a candidate in a democratic election, that they have no standing to challenge the rules governing that election simply because those rules didn't cost them the specific race in question is a profound abdication of judicial responsibility. It essentially says the process can be whatever the state wants it to be as long as the challenger still won. Think about that. Think about what that standard actually means and how it insulates questionable election practices from legal scrutiny by making the threshold for challenge nearly impossible to meet. Now let's talk about what the Supreme Court said, because the ruling itself is significant in ways that go beyond the politics of one congressional race in Southern Illinois. In a 7-2 decision, the justices reversed the lower courts and ruled that Bost did, in fact, have legal standing to bring his case. The majority opinion was authored by Chief Justice John Roberts, and it was joined by all 5 of the court's conservative justices, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, as well as liberal Justice Elena Kagan. That's a coalition worth pausing on because it tells you something important about how this ruling was framed. This was not a party line decision. This was a decision about standing doctrine, about who gets to walk into a federal courthouse and challenge an election rule, and it cut across ideological lines. Roberts wrote the candidates are not, in his words, mere bystanders in their own elections. They have, he continued, an obvious personal stake in how the result is determined and regarded. Read that sentence again slowly. What Roberts is articulating is not a radical position. It's actually a fairly intuitive one. So if you are the candidate in an election, if your name is on the ballot, if your political future hangs on the outcome, then you have a direct and personal interest in whether the rules governing that election are being followed correctly. The idea that you need to prove the disputed rules actually flipped the race. Before you can even challenge them in court, Roberts is saying that standard sets the bar impossibly high and insulates lawbreaking from accountability. And here's why that matters beyond this specific case. The standing doctrine has historically been used as a gatekeeper, a procedural hammer to shut down election challenges before they ever get heard on the merits. Whether you're a Democrat challenging voter suppression laws or a Republican challenging ballot counting rules, the prove it changed the outcome standard has been a wall that makes meaningful legal accountability nearly impossible. What Roberts and a 7-2 majority just did is lower that wall, not eliminate it, but lower it, so that candidates can at least get their cases heard, and that's consequential. That's a structural shift in how election litigation works in this country. But let's be rigorous here and give the dissent the honest treatment it deserves, because Justices Ketanji Brown, Jackson, and Sonia Sotomayor raised real constitutional concerns that shouldn't be dismissed. With a wave of the hand, their core argument is rooted in Article 3 of the Constitution, which limits federal courts to hearing actual cases or controversies. That means real, concrete disputes involving real, concrete harm, not hypothetical injuries, not abstract procedural grievances. Jackson, writing for the dissent, called the majority's ruling a dubious departure from settled law and accused the majority of creating a special, lowered standing threshold for political candidates that doesn't apply to ordinary citizens. That's not a crazy argument. The concern is real. If you dramatically lower the bar for candidates to challenge election rules, you potentially open the federal judiciary to a flood of litigation from losing candidates who want to relitigate every close race by attacking the procedural rules after the fact. Think about what that looks like at scale. Every competitive congressional race, every close Senate contest, every tight gubernatorial election, all of them potentially subject to post-election legal challenges, grounded not in provable fraud, but in disputed interpretations of process. That's a form of electoral instability, and it's worth taking seriously. The federal courts are not infinitely resourced. They're already overloaded. And the prospect of turning them into a venue for relitigating every contested race under the banner of procedural challenges is a legitimate systemic concern. So here's the honest tension. The majority is saying that when the rules themselves may be unlawful, candidates must have a way to challenge them, regardless of whether the outcome was affected. The dissent is saying that the constitutional structure demands actual, demonstrable harm before federal courts can intervene. Both of those positions reflect genuine legal principles. Neither one is pure politics, dressed up as jurisprudence. What this ruling does, and what it genuinely does, is shift that balance. And understanding exactly where that shift leads us requires looking at the broader landscape of American election law. Because Illinois is far from alone, here's where the practical consequences begin to land. This ruling doesn't just affect Illinois, it doesn't just protect Mike Bost's right to challenge his state's ballot rules. What it does potentially is open the courthouse door for candidates across the country to challenge election rules in their home states without having to first prove that those rules cost them the election. And that has implications that span both parties and all 50 states. Consider this. At least 9 states currently allow mail-in ballots to be counted if received within a certain number of days. After Election Day, as long as they're postmarked by Election Day, California allows ballots received up to 7 days after the election. Nevada allows 7 days. Utah allows up to 14 days. These are not fringe practices. They are established rules in major states that affect millions of votes in every election cycle. Now, under this ruling, candidates who lose close elections in those states, candidates of any party, have a much stronger argument that they have standing to challenge those rules in federal court. The litigation landscape just shifted dramatically. And here's what makes it even more complex. The federal statute that Bost's lawsuit was originally built around, the one establishing a national election day, has never been definitively interpreted by the Supreme Court in terms of what it actually prohibits. Courts have gone back and forth on whether that statute bars states from counting ballots received after Election Day, or whether it simply requires that voting end on Election Day while counting can continue afterward. That question is now very much alive again, and this ruling makes it far more likely that the court will eventually have to answer it directly. For voters, this is both a legal and a practical matter. If you live in a state with extended ballot receipt deadlines, you've been told for years that mailing your ballot before Election Day is sufficient. You follow the rules, you did what your state told you to do. The prospect of federal courts overturning those rules after the fact or invalidating ballots cast in good faith under state law raises genuinely serious questions about retroactive disenfranchisement and the stability of democratic norms. These are not hypothetical concerns. They are the real ground-level consequences that need to be part of this conversation. Now, we need to have the conversation that most outlets refuse to have. Clearly, the one about election integrity versus voter access, because too many people have turned this into a binary where you're either a fraud denier or a voter suppressor. And the truth is more complicated and more urgent than either of those caricatures. The reality is this: both things can be true simultaneously. Voter suppression is real. It has a documented history in this country stretching back generations. Poll taxes, literacy tests, strategic polling place closures, voter roll purges that target minority communities. These things happened. These things still happen in subtler forms. Anyone who dismisses that history is either ignorant or dishonest. And election procedural irregularities are also real. Close races have been decided by disputed ballots. Chain of custody failures have compromised ballot integrity in documented cases. Rules that vary wildly from precinct to precinct create inconsistency that undermines equal protection. The problem is that our political culture has weaponized both of these realities. The right uses election integrity as a cudgel to justify restrictions that disproportionately burden working people, elderly voters, and communities of color. The left uses voter access as a shield to deflect any scrutiny of procedural looseness or administrative failure. And the people who pay the price for that dishonesty are ordinary Americans, the ones who stand in line for 3 hours to vote, the ones whose mail-in ballots get lost or rejected on technicalities, the ones whose faith in the entire system erodes a little more every election cycle because nobody in power seems genuinely committed to getting this right for everyone. We are now in 2026. The midterms are here. Congressional control is on the line, and we are having these arguments in real time in federal courts with a Supreme Court ruling freshly on the books that has shifted the legal terrain. If that doesn't feel urgent to you, I don't know what will wake you up. The question isn't whether we should have election rules. The question is whether those rules are applied consistently, transparently, and with genuine equal treatment for every eligible voter, regardless of race, income, geography, or party registration. That's the standard. It's not partisan, it's foundational. And we are nowhere near meeting it. If you believe that standard matters, and you should, regardless of which party you support, subscribe to this channel, share this video, and make some noise in the comments, because the only people who benefit from Americans staying confused and divided on this issue are the ones who profit from the chaos. So what does genuine reform actually look like? Because it's easy to be angry. It's easy to point at a Supreme Court ruling and say it's good or bad based on whether your team wins or loses. What's harder, and what's actually necessary, is thinking seriously about what a trustworthy American election system demands in 2026 and beyond. Let's be specific, because specificity is where accountability lives, and vagueness is where bad faith hides. First, the question of mail-in ballots and receipt deadlines needs a clear federal standard. Right now, states operate under a patchwork of rules that creates genuine confusion for voters and genuine legal uncertainty for candidates and election administrators alike. If Congress set a national election day, and it did, then there is a legitimate legislative question about what that means for ballot receipt deadlines, and Congress needs to answer it. Not leave it to be litigated election by election, state by state, in an endless cycle of lawsuits that nobody outside the legal profession can follow. That's a bipartisan legislative responsibility. and the failure to address it is a bipartisan failure. And given what the Supreme Court just did, that congressional failure is going to be felt in courtrooms across the country during this very election cycle. Second, election administration in this country needs resources, standardization, and independence. County clerks and election administrators are often underpaid, understaffed, and politically exposed. In many states, the chief election official is a partisan political figure, a secretary of state who ran on a party ticket and answers to party donors. That structural conflict of interest should trouble everyone. When the person responsible for administering an election has a political stake in its outcome, the appearance of impartiality is already compromised, regardless of individual integrity. Independent, professionalized election administration isn't a radical idea. It's how most stable democracies operate. The United States is an outlier on this, and that outlier status costs us credibility every single cycle. Third, voter access and ballot security are not mutually exclusive goals, and we need to stop pretending they are. You can have secure, verifiable mail-in voting with strong chain of custody procedures. You can have voter ID requirements that don't function as poll taxes. By ensuring that free, accessible identification is available to every eligible citizen, you can have automatic voter registration that expands participation while maintaining accurate rolls. These are engineering problems, not ideological impossibilities. The reason we haven't solved them is not because they're unsolvable, it's because too many powerful actors on both sides benefit from the current dysfunction. Division is profitable. Confusion is useful. A clean, trusted election system that everybody accepts that's actually threatening to a lot of people in power. The 2026 midterms are happening right now in this environment, with this Supreme Court ruling freshly reshaping the legal landscape. Candidates and their legal teams are taking note. State legislatures are recalculating. Election administrators are bracing, and voters, ordinary Americans who just want to know that their vote counts and that the process is legitimate, are watching all of it and asking a question that should haunt every institution in this country. Can we actually trust this? That question doesn't have a clean answer right now, and that's an indictment of everyone who has had the power to fix this and chose not to. Here's what I need you to do before you close this video. Not because it helps me, because it helps you, and because it helps the country. Talk about this not in the tribal way, not as another ammunition round in the culture war, but as a citizen who understands that elections are the mechanism by which ordinary people exercise power over the institutions that govern their lives. When that mechanism is compromised, when trust in it collapses, what replaces it is not freedom. What replaces it is raw power, unaccountable and unchecked. We have seen what that looks like throughout history, and we are not so exceptional that it cannot happen here. The Supreme Court just reminded this country that the rules of an election matter and that candidates have standing to demand those rules be followed. Now, the rest of us, voters, journalists, legislators, citizens, need to take that principle seriously and demand not just that the rules be followed, but that the rules themselves be worthy of a functioning democracy. And that's not a partisan position. That's the only position that makes sense. If you actually believe in this country, subscribe, leave your thoughts below, share this with someone who needs to hear it, and stay awake. Because nobody else is going to do this for us.